Okay, so once again, very good afternoon to all of you, and welcome to the discussion on Section 194H. Uh, this basically, recently on 28th Feb, the Honorable Supreme Court of India gave the findings in the case of Bharti Cellular Limited, wherein the Supreme Court analyzed in detail the applicability of 194H. So today, in today's presentation, I would be discussing various issues discussed by Supreme Court, and I believe it rests the discussion on the applicability of 194H. And if you have any of such transaction, or you are paying commission, or you are distribution, you have got franchisee or distributors, I trust this judgment would going to be pretty useful for you. So broadly, what 194H is all about: 194H casts the responsibility on the payer to deduct a TDS if the payer is paying a commission or a brokerage. And this TDS needs to be deducted at the time of credit of such income or payment of such income, whichever is earlier, and the rate of deduction of TDS is 5%. There are other provisions also, that when it would be applicable on individual or HUF, and when it would not be applicable on individual or HUF. And the basic threshold is the 15,000, that until unless the aggregate value of the transaction during the year with the payee is more than 15,000, Section 194H is not applicable, or one can say that the TDS under Section 194H is not applicable. Then as we move, we have an explanation which gives the meaning of, or defines commission or brokerage, and it is an inclusive definition which clearly highlights that commission or brokerage is payable to an agent, that is a person acting on behalf of another person. So, by whatever name we call commission or brokerage, but if it is a remuneration for services to a person wherein that such person is acting on behalf of the another, uh, in the course of buying or selling of goods, or in relation to any transaction relating to any assets, valuable article or thing, not being securities, then such remuneration would be regarded as commission or brokerage, and it would fall within the ambit of 194H. But yes, it specifically excludes professional services from its ambit, and it defined professional services as the legal, medical, engineering, or architectural profession, or profession of accountancy, or technical consultancy, or interior decoration, or such other profession, as may be notified under Section 44AA. It defines securities, it defines suspense account, which we guys are regular in understanding and dealing with. So broadly, once again, Section 194H is applicable when someone makes a payment to the resident, that someone is a person, that person may be an individual or HUF, or maybe anyone else, depending upon whether the individual or HUF, the tax audit is applicable on them or not. If the income paid is commission or brokerage, what commission is commission or brokerage is, if somebody is supporting you in buying or selling of goods or similar transactions, then the remuneration to that someone, that agent, is commission or brokerage. And if that commission or brokerage during the year in aggregate is more than 15,000, then one needs to deduct a TDS at the rate of 5%. So this is broadly about 194H. Now, the litigation in this matter, and otherwise also, if you see the other case laws, or the matter which is given to the court, uh, is basically more on the discounts given by, let's say, the manufacturer, or the cellular companies, or the the companies dealing in any product, to the distributors or franchisees. And the question is whether this discount, which is given by a manufacturer or by a producer to distributor or franchisee, falls within the ambit of commission or brokerage, and thus 194H is applicable or not. So this judgment clearly, supports or defines, or gives a very good ground, very good principles that one can understand and apply in order to see whether such discounts fall within the purview of commission or brokerage or not. The brief facts in this case were that the Bharti Cellular is a mobile telephone service company, which we all know, which is operating in different circles and very well regulated and working as per the license given by Department of Telecommunications of Government of India. So as per the business model, there are two business models broadly: the postpaid and prepaid connection. This judgment relates to prepaid connection, wherein the prepaid SIMs were sold to the users. But before the SIMs goes in the hand of the user and mobile phone of the users, the SIM use the SIM card initially from a Bharti used to go to the franchisors or distributors, and from the franchisors or distributors to the retailers, and from the retailers to the customers, to the final customers. Now, what Bharti used to do, they used to sell it at a discount. For example, let's say the value, the talking time value in the card is 100, so they might give it for 90 or 85 to the franchises and distributors, and then they were accordingly used to give further discounts to the retailer, and then retailer used to sell it maybe at the full value or maybe at a discounted value to the customers. And there used to be also startup pack, which was used to be sold in similar fashion. So the question that came before the Honorable Apex Court, that whether the discount which is given by Bharti or a cellular company in this case to the distributor or franchisors is basically a commission or brokerage under section 194H or not. So this was the basic question which came before the Supreme Court. And when most of us would be having some thought whether it should be commission or brokerage, or it is simply should be seen as discount, it is point to understand that this matter went to the Supreme Court of India. So what is your view, the friends who are listening this, according to you, whether such a discount should be considered as commission or brokerage, or it should be considered simply a discount and TDS should not be applicable? You may give your brief reply in a chat box. Any views, any reply whether this discount should be considered as commission or brokerage, or it should be simply considered a discount and there should not be applicability of 194H. So we have one view from Manish ji. Manish ji saying it is not a commission. Rajesh ji saying it is only a discount. And do we have any other view, or should I proceed? Okay, so let me proceed on this. There are some more facts, which we need to understand. And these facts are that the marketing rights were given to the distributors and retailers. Uh, they were allowed to market or appoint retailers for the sales promotion. They were allowed to do only activities which were mentioned in the agreement, and they cannot sell the SIM cards, or they cannot distribute the SIM card of any other company. So they were dedicatedly working for Bharti in this case. They need to maintain a suitable establishment for the conduct of business and performance obligation. They need to have proper policies. They need to have proper team in their office to look into the sales, or to look into, to explain to the customers about various issues. At no point of time, the right, title, or interest in the prepaid card shall pass on to the franchisee or distributors. So the right, title, or interest was always with the Bharti, though the cards, the SIM cards came from Bharti to the distributors, but right or interest was always with the Bharti. All rights and title ownership and property in the card shall rest with the taxpayer, that is with the Bharti. The franchisee distributors were required to pay in advance the price of the welcome kit containing the SIM card, recharge vouchers, top cards, e-tops. They used to pay in advance, and then they used to buy the cards. The franchisee distributor was free to sell the prepaid products at any price below the price printed on the pack. So they can sell at any price uh, below 100. That is, if 100 is the maximum retail price, they can sell at any price below 100. How invoice is made? Rajesh, invoice was made for 90. So if I'm buying from you for 90, let's say if I'm a distributor, and you are saying the discounted price for the same is 90 or 85, I will raise an invoice of 90 or 85 on you, and you will raise an invoice on me, and I will give it in rupees 90 and buy from you. But the ownership was with the Bharti or Airtel. So broadly, the Supreme Court analyzed that, that under Section 194H, what is important that in order to qualify something as commission, there must be a principal agent relationship. So until unless this principal agent relationship, is there, the remuneration given to a person would not qualify as a commission, because commission is a remuneration to an agent for the services provided by that agent to the principal. So explanation one clearly says that Section 194H of the Act restricts application of Section 194H to the services rendered by the agent to the principal in the course of buying and selling of goods, or in relation to any transaction relating to any asset, valuable articles or thing not being securities. So this obligation to deduct TDS only exists or is only there when there is a legal relationship of principal and agent. When we say legal relationship, means that the relationship is governed by law. That yes, that I have agreed to become your agent and you have agreed to become my principal, and now we have a, in the contract act, we have a the full detail about how the principal and agent relationship works, and we are working as per that law. And this principal agent relationship is certainly a triangular relationship between principal agent and third party, wherein the agent is dealing with the third party on behalf of principal. And by doing this, by dealing it with third party, there are a lot of, there are four factors, which are impacting this relationship. So by dealing with the third party, the agent has got a right or a legal power to alter the relationship between the principal and the third party, and also to alter the liability which principal is having. So for example, if I am entering into a contract with you. Let's say if I'm an agent of a principal, if I'm entering into contract with the third party, then whatever the contract I have entered is applicable on the principal. And because of that contract, the legal relationship between the principal and the third party will change. Plus, the liability of a principal towards me and towards the third party will also change. Now, agent is acting on behalf of the principal. Agent is not acting on its own behalf. If they are buying goods or whatever the SIM card is there, when I'm selling it on my behalf, on behalf of the principal, and uh, not on behalf of the on myself. I'm selling it on behalf of principal. Whatever the agent is doing on behalf of principal. There is a fiduciary relationship between the principal and agent. There's a relationship of trust, that whatever goods are lying with me, those goods are whatever the goods are lying with the agent, those goods are of the principal. Whatever money the agent is collecting, that money is for the principal. Now, whatever the actions agent is taking, because the agent is taking action on behalf of the principal, there's, the agent needs to act in favor of the principal. Further, the last important factor which defines the principal and agent relationship is that because agent is acting on behalf of the principal, agent is liable to render accounts to the principal. So because the uh, remuneration is dependent upon the sales made by the principal, sales made by the agent. So the agent will give access of its account to the principal, so that principal can know, okay, what amount of sales you have made, and if you have made X amount of sales, I will give you Y amount of commission or Y amount of income, because you are acting on my behalf. And if you are acting on my behalf as an agent, I have got full access to your accounts. Whereas if you see principal to principal relationship, all these factors are missing on in principal to principal relationship. When we are acting as principal to principal, I will not share my accounts with you. I may be your distributor or a franchisee or a retailer. I will not share my accounts with you at what price I have sold. What matters is to you is, at what price I have bought, but at what price I have sold does not matter to you. uh, the goods which are with me belongs to me. I will take the decision, or I will act which is in my favor. Not, I'm not worried about you, because we are acting on principal to principal. I'm not acting on your behalf. I'm on this bullet. We are not acting in principle to principle. Both the parties act on independent basis, not on behalf of anyone else. Uh, and I cannot alter the relationship between you or anyone else, because I'm acting on my own behalf independently. The last is the agent is authorized to sell or buy on behalf of the principal, whereas the essence of contract of sale is transfer of the title of goods for the price paid or promised to be paid. Uh, in principal to principal, when the goods are transferred from one principal to another, not only the goods but the title also in the goods get transferred. Whereas in case of the agent, if the goods are transferred from principal to agent, goods still remain of the principal and not of the agent. So now, when we were discussing that in case of the SIM card, the value, the property was still with the Bharti. So this is one of the important point which was raised by the department, that the SIM was still owned by the uh, Bharti Cellular Company, and the rights in the SIM was still with the Bharti and not with the uh, distributor or franchisee. So now, what is your view on this point? Because this is a very important point which was raised by the department, that, though the SIM card are lying with the distributor or franchisee, but still, they were not having any right, title or interest in the prepaid cards, because that will pass on from the the company, the Bharti Cellular, to directly to the users. And whereas if we see, it says clearly, says the agent is authorized to sell or buy on behalf of principal, whereas the essence of contract of sale is the transfer of title of goods or the price paid or to be paid. So the department took a view that in this case, being the rights are still with the company and not with the distributor or franchisee. Now the indeed, the franchisee or the distributor, they are selling uh, SIM card on behalf of Bharti, and thus the same should be regarded as principal and agent relationship, and the discount should be considered as commission. So, what is your view? Before we proceed, let's check if there is any change in the view or the views are still same. Any views? No. Okay, so let me proceed. So we have one view. Manish ji is saying it is still same. Okay. So let me proceed. The person responsible for paying, the liability to deduct TDS is on the person responsible for paying. Who is responsible for paying in this case? Whether it is the Bharti Cellular Company or it was the retailers who were buying. And the question came whether retailers were buying on their own behalf or on behalf of Bharti Cellular. So while giving the judgment, the Supreme Court said that it is as per the regulation of the telecom authority that the rights or title in the SIM card will directly get transferred from Bharti or a cellular company to the users. So because of that, the rights were with the Bharti, but otherwise, the transaction was the SIM card purchased by the distributors or franchisers were sold by them to the retailers on principal to principal basis. And they were free to decide the price at what price they want to sell. It was just a condition that they cannot sell more than an MRP. So the transaction was from Bharti to the distributors or franchisee, let's say at 90. And then after that, the Bharti or the franchisee were free to sell for X price, maybe 95, 96 to the retailers. And the retailers were buying on their own behalf and not on behalf of Bharti. So thus the payment which was credited to the franchisee or distributors were not by the Bharti. And thus Bharti was not the person responsible for paying. The person responsible for paying in this case was uh, the retailers. So they said being Bharti is not the person responsible for paying income to the distributors or franchisees, hence it will not fall within the purview of 194H. So Supreme Court analyzed this 194H from different angles, and this was one of the angle which Supreme Court analyzed. Further, Supreme Court analyzed that the accounts of distributors or franchisee, the access to those accounts of distributor and franchisee was not given to the Bharti. So Bharti was only considered that, if I'm selling you 90, you sell at X price, but you need to follow a regulation that you will not sell beyond 100. But whether they were selling at 91 or they were selling at 92 or 95 or 96, that was not the concern of Bharti. Bharti was not giving any income to the distributors. There was another matter in the case of Singapore Airlines, wherein there was a same section 194H was analyzed by the Supreme Court. And in case of airline companies, what happened? They sell the tickets at the discount to the to the agents, and the agent used to get a fixed commission. Further, the airline company, so what airline company used to do, let's say there is a retail price of X rupees, 100 rupees. On 100 they will give a fixed commission, but while remitting the money, while this travel agents are remitting to the money to the airlines can give further discounts. So the matter went to the Supreme Court, and Supreme Court analyzed the same. We can also analyze the judgment, that judgment based on the principles that we have understood here. Now you can see that the excess of accounts of agents were given the uh, to the airline companies. Airline companies were indeed involved in setting the commission rate, whether 7%, 10%, or any extra commission needs to be given. So now the title in the tickets were also passing from the airline to the retailers, to the customers. So all the factors which are there are satisfied, and the agents do qualify as a principal to agent relationship, and hence the commission or the charges given by the in the matter of Singapore Airlines to the agent were considered as a commission under section 194H, and the applicability, with regard to applicability, uh, Apex Court said yes, TDS is applicable. Similarly, you will find that a lot of judgments in case of stamp vendors, and in this case also it was regarded that once the stamp are sold to the agents, then they are free to sell at a price as per their own wish. But the property and goods got transferred from the association to the stamp vendors, and that should not be regarded as the commission. Now, in case of, if you see there is a case of Delhi Milk Scheme and Mother Dairy. In both cases, the models were different. In case of Delhi Milk Scheme, the distributors or the agents, they were acting on behalf of the company, and if the milks were not sold, they can refund the milk, they can send the milk back. Whatever the collection they were doing, they were sharing that collection with the Daily Milk Scheme company. So in that case, the discount to the agents were regarded as the commission under section 194H and TDS were applicable. But whereas if you see the matter of Mother Dairy, in that case, though the booth were owned by the Mother Dairy, they the distributors or agents were operating from those booths, but the risk in the goods were with the distributors or agent operating from the booth, and the income also belonged to them, the risk also belonged to them. So the court said that in that case, the relationship is between principal to principal, whereas in case of Delhi Mill scheme, the relationship is of principal to agent. And they said, again, in one matter, it would be regarded as commission in Delhi Mill scheme, whereas in Mother Dairy, it was regarded that it would not qualify as commission because of principal to principal relationship. Now, the observation of apex court in this case is certainly, what few of the friends text that, it would not be regarded as commission, and it would be a transaction which should be seen as principal to principal. But what observation they made is that franchisee or distributor receives payment when the third party makes the payment. This payment is not the payment received or payable by a taxpayer as the principal. So they're not making the payment as the principal. The distributor franchise is not the trustee who is to account for this payment to the taxpayer as principal. The money received by the distributor franchisee belongs to them, and they will not going to give it to back or showcase what they have earned to the uh, Bharti. The payment received is the gross income or profit earned by the distributor franchisee. It is the income earned by the distributor franchisee as a result of its efforts and works, and not a remuneration paid by the taxpayer as a cellular mobile telephone services. The taxpayer would be liable to deduct tax at a source even if the taxpayer are not making payment or crediting the income to the account of the franchisee distributor. When the obligation and the time and the manner in which the tax is mandated by law to be deducted source is fixed by the statute, the same cannot be shifted, altered, modified, postponed on a concession in the court by the revenue. Very important judgment. When the law clearly says that when tax is needs to be deducted, how it needs to be deducted, department cannot change the modus operandi of the section. The taxpayer does not have privy to the transactions between franchisee, distributor, and third parties. At what price they are selling, we don't have the access. Bharti does not have the access. It is therefore impossible for the taxpayer to deduct TDS and comply section 194H. The taxpayer would not be under a legal obligation to deduct tax at source on the income profit component in the payment received by the distributors franchisee from the third party's customer, or while selling transferring the prepaid coupons or starter kits. So that is section 194H is not applicable to the facts and circumstances of the case. So this was basically the judgment by the apex court. And now if you have some question on section 194H, I would be happy to take those questions. You can either put it in a chat box or unmute yourself and ask the question. I would be sharing the presentation in my WhatsApp community group. I trust you all are there in that WhatsApp community group. So any questions? So I thanks all of you for joining today's discussion. It is once again a pleasure to share what I can understand from the judgment. Thank you and see you soon.
Thank you.